A Republican-appointed federal judge just did something that sources are calling absolutely unprecedented, and it could trigger the most serious constitutional confrontation between the judiciary and Trump administration yet. We're not talking about stern warnings or expressions of concern. We're talking about reports that Chief Judge Patrick Schiltz, a George W. Bush appointee and former clerk to Justice Antonin Scalia, has ordered the acting head of ICE to personally appear before his court for contempt proceedings. That he wrote the order is an extraordinary step, but that ICE's violations of court orders are likewise extraordinary. And sources suggest what might make this moment so significant is that this isn't some liberal activist judge.
Border Patrol Commander Greg Bovino and some, not all of the Border Patrol agents will be leaving the state imminently. There were some 3,000 federal agents involved in this immigration crackdown, around 2,000 on the ICE side, 1,000 on the Border Patrol side.
This is a veteran of the conservative legal movement who allegedly finds himself forced to confront Trump administration's systematic defiance of judicial authority. When Republican judges appointed by Republican presidents start holding Trump officials in contempt for ignoring court orders, that might not be partisan politics. That could be federal judiciary defending its constitutional authority against executive branch that refuses to respect the rule of law. But before we break down everything, please subscribe to our channel, John Brown Show. Your subscription actually matters here. All right, let's get into what Judge Schiltz actually wrote in his contempt order and why sources suggest this represents breaking point for federal judiciary that has watched Trump administration systematically ignore court rulings. Because Judge Schiltz didn't just express frustration or threaten consequences. Reports indicate he documented dozens of instances where ICE violated court orders, where people were kept detained after courts ordered their release, where individuals were flown to Texas when courts said they must remain in Minnesota, where bond hearings ordered by courts simply didn't happen, and he allegedly concluded that lesser measures have been tried and failed, which is why the extraordinary step of ordering agency head to appear personally has become necessary. When conservative judge documents that pattern of defiance and orders contempt proceedings, that's not judicial activism. That might be last resort response when executive branch treats court orders as suggestions rather than binding legal requirements. And if ICE director refuses to appear or appears and offers inadequate explanations, sources suggest Judge Schiltz could impose sanctions that escalate this into constitutional crisis, where question becomes whether courts have any real enforcement power against administration determined to defy them. Let's start by documenting what Judge Schiltz laid out in his order about ICE's systematic violations of court rulings. Because sources suggest this isn't about one or two disputed cases. This is allegedly a pattern of dozens of violations where court orders were simply ignored. The judge cited specific example of a petitioner named Juan, who was granted habeas relief. The court ordered that ICE provide bond hearing within 7 days or immediately release him from detention. That's not suggestion. That's court order with specific timeline and consequences for non-compliance. But reports indicate ICE didn't comply. 7 days passed. No bond hearing. Juan remained detained in violation of court order. When his lawyer notified the court about the violation, Judge Schiltz discovered this wasn't an isolated incident. Sources suggest he wrote that this is one of dozens of court orders with which respondents have failed to comply in recent weeks. Think about what that means. Not one violation, not a few cases where there might be legitimate confusion, dozens of court orders being systematically ignored. And the consequences allegedly aren't just procedural. Judge Schiltz documented real harm to real people, detention being extended illegally, people who should remain in Minnesota being flown to Texas, individuals released in Texas and told to figure out their own way home after all their money and belongings are taken. Reports suggest these are people who have lawfully lived and worked in the United States for years and done nothing wrong other than having immigration paperwork issues. And ICE is violating court orders about how they're treated. Think about the specific scenarios Judge Schiltz described. Sources indicate courts order someone released. ICE keeps them detained anyway. Courts order bond hearing. ICE doesn't provide it. Courts specify someone must remain in specific jurisdiction. ICE flies them to different state. That's not just aggressive enforcement, that might be contempt of court happening systematically across dozens of cases. Make sure you're subscribed to John Brown's show, because what makes this particularly damning is Judge Schiltz's background. Reports indicate he's former Scalia clerk, conservative legal movement veteran, George W. Bush appointee. This isn't judge with reputation for liberal activism or hostility to immigration enforcement. When someone with his credentials documents systematic violations and orders contempt proceedings, that carries weight that crosses ideological lines. This might not be political disagreement. This could be straightforward documentation that Trump administration is violating the law. But Judge Schiltz's contempt order reportedly wasn't his first extraordinary action in response to Trump administration's tactics. Sources suggest he previously sent unprecedented letter to 8th Circuit Court of Appeals about DOJ's attempt to force arrest of journalist Don Lemon. And that earlier incident might reveal pattern where Trump administration treats federal courts with complete disregard for normal legal processes. Reports indicate Trump administration wanted to arrest Don Lemon and others who were present at demonstration at church in Minneapolis. The magistrate judge reviewed the evidence and declined to approve the arrests. That happens sometimes in legal system. When magistrate doesn't find probable cause, prosecutors typically go back and strengthen their case or take it to grand jury. But sources suggest Trump's DOJ didn't do that. Instead, they allegedly filed mandamus petition with 8th Circuit trying to force the judge's hand, and they did it in extraordinary way. Filed it under seal so it was confidential. Never served Judge Schiltz with papers so he couldn't respond to whatever accusations they were making about his court. And they did all of this while Judge Schiltz was on his day off helping his son who has disabilities. Think about what that reveals about Trump DOJ's approach to courts. When they don't get ruling they want, they don't follow normal legal process. They allegedly run to appellate court claiming the judge is wrong. They make it confidential so judge can't defend himself. They file mandamus, which is extraordinary remedy reserved for clear abuses rather than routine disagreement about probable cause. That's not respect for judicial process. That might be attempt to intimidate judges into compliance. And Judge Schiltz's letter reportedly documented how unusual this was. Sources indicate he wrote that he'd never seen DOJ bypass normal processes this way, that he'd consulted with other district judges and none of them had seen it either. When judge handling case has to write letter saying, "I don't even know what I'm being accused of because they filed it confidentially without serving me," that's not normal adversarial process. That might be abuse of court system. The 8th Circuit allegedly denied the mandamus summarily. Conservative appellate panel looked at Trump DOJ's extraordinary request and said no. That's significant because reports suggest even conservative judges recognized this was inappropriate overreach. When your own ideological allies on appellate courts reject your tactics as improper, that indicates you've gone too far. Share this video with everyone you know because sources indicate the Don Lemon mandamus connects to broader pattern. Trump administration treats judges who rule against them not as neutral arbiters applying law, but as obstacles to be circumvented or intimidated. When magistrate doesn't approve arrest, they run to appellate court. When district judge orders bond hearings, they ignore the orders. That systematic disrespect for judicial authority is allegedly what led Judge Schiltz to the extraordinary step of ordering ICE director to appear for contempt. But let's talk about what actually happens when ICE director is ordered to appear for contempt hearing. Because sources suggest this creates several possible scenarios, none of them good for Trump administration. First possibility is that acting ICE Director Todd Lyons actually appears as ordered. If he shows up, Judge Schiltz can question him directly about why court orders are being violated, why bond hearings aren't happening, why people are being moved between states in violation of court directives, why ICE appears to be systematically ignoring judicial authority. And reports indicate if Lyons can't provide satisfactory explanations, the judge has contempt powers he can exercise. Fines against ICE or potentially against individuals responsible for violations. Orders requiring specific compliance measures. Threat of more severe sanctions if violations continue. All of those tools allegedly give courts enforcement mechanisms when executive branch defies them. But they only work if the person ordered to appear actually shows up and provides truthful testimony. Second possibility is that Trump administration tries to send someone other than Lyons. Sources suggest DOJ might argue that agency head can't possibly appear, he has other responsibilities, someone else can represent ICE. And there's legal doctrine called Apex Doctrine that normally protects top officials from having to personally appear in individual cases. You can't usually force CEO of Microsoft to testify in every lawsuit against the company. Subordinates handle most proceedings. But think about whether that doctrine applies here. This isn't one case. Reports indicate Judge Schiltz documented dozens of violations across multiple cases. This is systematic pattern requiring explanation from person at top. And the judge specifically wrote that the extraordinary step of ordering agency head is justified because the extent of violations is likewise extraordinary. When you have that many court orders being ignored, Apex Doctrine might not shield the person ultimately responsible. Third possibility is that Trump administration simply refuses compliance. Sources suggest Lyons doesn't show up. DOJ files motion arguing judge lacks authority to compel his appearance. They treat the contempt order itself as something they can ignore. That would create direct confrontation between judicial and executive branches, where question becomes what happens when court issues order and executive branch says no. And that's where constitutional crisis potentially emerges. If judge can't enforce his own orders, if contempt power becomes meaningless when executive branch refuses to acknowledge it, judicial authority might become theoretical rather than real. The entire system of checks and balances allegedly depends on branches respecting each other's constitutional powers. When that breaks down, you get authoritarianism, where whoever controls executive branch can do whatever they want. The Eighth Circuit intervenes before Friday's hearing. Trump administration files emergency appeal arguing Judge Schiltz exceeded his authority in ordering ICE director to appear. Conservative appellate panel might agree that while violations are concerning, ordering agency head is too far. They could reverse or modify the order in ways that allow someone else to appear instead. But Judge Schiltz isn't alone in confronting Trump administration's defiance of court orders. Sources indicate federal judges across the country are facing similar patterns of ICE violating rulings about bond hearings, detention, and due process. And other judges are beginning to push back with sanctions and contempt threats. Reports suggest Judge Roy Dalton in Florida has threatened sanctions against U.S. attorney for willful wholesale failure to cite relevant cases. That he's ruled Trump's policy of denying bond hearings to detained migrants is unlawful. And he's holding Trump administration accountable for not following established legal precedent. Think about what it means when multiple federal judges in different jurisdictions are all documenting the same pattern. This isn't one rogue court. This allegedly is systematic problem where ICE is operating in ways that violate constitutional requirements across the country. When judges in Minnesota, Florida, and other states all reach similar conclusions about violations, that suggests the problem is real rather than just judicial bias. And sources indicate the specific violations are consistent. People being denied bond hearings they're entitled to, individuals being detained without proper legal process, court orders being ignored when they require release or specify conditions. All of that points to what might be deliberate policy rather than accidental failures. When the same violations happen in dozens of cases across multiple states, that's not coincidence. That could be Trump administration deciding court orders about immigration don't bind them. But there's reportedly another pattern Judge Schiltz noted that's particularly troubling. The people whose rights are being violated aren't the dangerous criminals Trump claims to be targeting. Sources suggest Judge Schiltz wrote that many are people who have lawfully lived and worked in the United States for years and done nothing wrong. Their only issue might be immigration paperwork not being in perfect order. Some allegedly came illegally decades ago, but have since been productive community members paying taxes and following laws. If Trump administration's stated priority is removing dangerous criminals, why are court violations happening in cases involving people who've done nothing wrong except paperwork issues? Why are resources being devoted to people who came illegally 40 years ago but have been model residents since? That disconnect between stated priorities and actual enforcement might indicate this isn't about public safety. This could be about creating atmosphere of fear and demonstrating that nobody is safe from deportation, regardless of their actual conduct. But Judge Schiltz's order reportedly addressed another issue beyond just violations of specific court orders. Sources indicate he documented that ICE operations have created massive burden on federal courts without any coordination or planning. That hundreds of habeas cases are now pending in Minnesota because of how ICE conducted what they call Operation Metro Surge. And Trump administration made no arrangements for how federal judiciary would handle this caseload. Think about what proper coordination looks like. Reports indicate when DOJ conducted major series of January 6th prosecutions, they coordinated extensively with courts, made arrangements for judicial resources, ensured the system could handle the volume. When Pittsburgh implemented gun reduction initiative, bringing many federal cases, prosecutors coordinated with judges about capacity and scheduling. That's normal professional practice when you're going to generate significant court workload. But sources suggest ICE showed no such respect for judicial process in Minnesota. They allegedly surged into the city, conducted aggressive operations generating hundreds of detention cases, and left federal courts to figure out how to handle it all. No advance coordination, no resource planning, no consideration for whether courts could manage the volume. That's not just discourteous. That might reveal fundamental disrespect for judiciary as co-equal branch of government. And Judge Schiltz apparently contrasted this with how things should work. When you're planning operations that will generate legal proceedings, you coordinate with courts. You ensure judicial resources exist to handle cases properly. You show basic respect for the system. Sources indicate Trump administration did none of that. They just invaded, as Judge Schiltz allegedly described it, and created chaos that courts are still trying to manage. But there's reportedly another element. The lack of coordination makes it harder for courts to protect constitutional rights. When hundreds of cases flood systems simultaneously without warning, judges struggle to give each one proper attention. People might sit in detention longer than necessary because courts are overwhelmed. Rights violations might not be caught as quickly. All of that serves Trump administration's interests if their goal is processing people as quickly as possible without careful review of whether detention is legally justified. Now, sources suggest this mirrors pattern elsewhere. When Trump administration wants to accomplish something courts might obstruct, they create conditions where courts can't function effectively. Flood the system, ignore coordination norms, treat judiciary as obstacle rather than partner in upholding law. And when judges push back, attack them as partisan or claim they're interfering with executive authority. That's not how constitutional system is supposed to work. So what actually happens on Friday when this contempt hearing is scheduled? Because sources suggest several possibilities depending on how Trump administration responds and whether appellate courts intervene. If Lyons actually appears as ordered, reports indicate the hearing could be extremely uncomfortable for him. Judge Schiltz has documented dozens of violations. He can question Lyons about each one. Why did this person not get bond hearing? Why was that individual moved to Texas? What's the explanation for systematic pattern of ignoring court orders? And if Lyons provides inadequate answers, sources suggest the judge has range of sanctions available. He could impose daily fines until compliance is achieved, could order specific remedial measures ICE must take, could make findings that support civil or criminal contempt charges, could refer matters to higher authorities. All of those consequences create pressure for Trump administration to actually start following court orders rather than treating them as optional. But think about what happens if DOJ convinces Judge Schiltz or 8th Circuit that someone subordinate to Lyons can appear instead. That person still has to answer the questions, still has to explain the pattern of violations. Sources indicate even if it's not the very top person, whoever shows up Friday is going to face detailed questioning about why Trump administration thinks it can ignore federal judges. And those answers become part of record that could be used in other cases or appeals. Third scenario is that Trump administration defies the order entirely. Reports suggest they file appeals, seek emergency stays, argue Judge Schiltz exceeded his authority. Maybe they get 8th Circuit to intervene before Friday. But even if they succeed in avoiding this specific contempt hearing, the underlying issue remains. Dozens of court orders are being violated. Judges are documenting systematic defiance. That record exists regardless of whether this particular hearing happens. And there's reportedly broader question. If Trump administration successfully avoids accountability here, what message does that send to other courts? Sources suggest judges nationwide are watching this. If ICE can systematically violate orders in Minnesota without consequences, why would ICE comply anywhere else? That could embolden even more aggressive defiance of judicial authority throughout the system. But if Judge Schultz succeeds in compelling appearance and imposing consequences, that might establish precedent that courts won't tolerate systematic violations. Reports indicate other judges could follow his example. Start ordering contempt proceedings when their orders are ignored. Build record that could support broader legal or political accountability. That shift could force Trump administration to choose between moderating tactics or facing escalating conflict with federal judiciary. Multiple sources suggest there's also political dimension. These court battles are happening as Trump's approval craters and midterms approach. Images of administration defying federal judges, being held in contempt, having to explain violations under oath, all of that creates political ammunition for Democrats, reinforces narrative that Trump doesn't respect rule of law, and might motivate voters who care about constitutional governance to turn out against Republicans who enable this behavior. But step back and look at what Judge Schultz's contempt order reveals about the state of American constitutional system. Because sources suggest this isn't just about immigration enforcement or one judge's frustration. This could be a fundamental test of whether judicial branch can still check executive power when president refuses to respect court authority. The Constitution establishes 3 co-equal branches. Courts interpret law. Executive enforces it. But that system allegedly only works if branches respect each other's authority even when they disagree. When executive branch systematically ignores court orders, when violations happen dozens of times, when judge documents that lesser measures have failed, that's breakdown of constitutional structure. Sources indicate if courts can't enforce their rulings, if contempt power becomes meaningless, judicial review becomes theoretical. President can do whatever he wants because judges can't actually stop him. That's not checks and balances. That's authoritarianism with judicial window dressing. Think about the broader implications. If Trump administration succeeds in defying Judge Schultz, if they avoid consequences for systematic violations, what stops them from ignoring other courts? What happens when judge rules against some other Trump policy? Administration now knows they can just ignore it without real penalty. That precedent could spread beyond immigration to any area where courts try to constrain executive power. And sources suggest this is why Judge Schultz being conservative Republican appointee matters so much. This isn't partisan judiciary opposing Trump. This is member of conservative legal establishment defending judicial authority against executive overreach. When that ideological alignment doesn't prevent conflict, it indicates the problem isn't politics, but rather fundamental constitutional crisis. But there's reportedly another element. The specific people being harmed by these violations are ones Trump administration supposedly isn't targeting. Long-term residents, people who've done nothing wrong except paperwork issues, model community members. When court orders protecting those individuals are violated systematically, that reveals enforcement isn't about public safety. That might be about demonstrating nobody is safe, creating fear through unpredictable and lawless enforcement. Sources suggest international community is watching too. When American federal judges document that their own government systematically violates court orders, when constitutional system appears unable to constrain executive lawlessness that damages America's standing as rule of law nation. Authoritarian governments can point to it as evidence that US is no different. Allies might question whether they can trust American commitments. The damage extends far beyond these specific immigration cases. So here's what Judge Schultz's contempt order reveals about where Trump administration stands with federal judiciary. A conservative Republican-appointed judge documenting dozens of systematic violations of court orders. People kept detained after courts ordered release. Individuals moved between states in violation of judicial directives. Bond hearings that courts mandated simply not happening. and judge concluding that extraordinary step of ordering ICE director to appear is justified because the extent of violations is likewise extraordinary. The Friday contempt hearing creates multiple possible scenarios. If Lyons appears and provides inadequate explanations, he could face sanctions and orders requiring compliance. If Trump administration sends subordinate or refuses compliance entirely, that triggers questions about whether courts can enforce their authority. If appellate courts intervene to shield agency head, underlying violations still exist and other judges might pursue similar contempt proceedings. None of these scenarios end well for administration that's built strategy on defying judicial authority. The pattern extends beyond Minnesota. Judges in Florida and other jurisdictions documenting similar violations. Courts nationwide facing same systematic defiance where ICE ignores orders about detention and due process. When multiple federal judges reach identical conclusions about constitutional violations, that's not judicial activism. That's documentation of real pattern requiring accountability. What makes this most significant is Judge Schiltz's background. Former Scalia clerk, conservative legal movement veteran, Bush appointee. When someone with those credentials orders contempt proceedings, that transcends partisan politics. This might be a straightforward case of federal judge defending judicial authority against executive branch that refuses to respect rule of law. And that defense matters for entire constitutional system. The implications if Trump administration succeeds in avoiding accountability are profound. If systematic violations of court orders produce no consequences, judicial review becomes meaningless. If contempt power can't be enforced against resistant executive, checks and balances fail. Future presidents learn they can ignore courts without penalty. That's path toward authoritarianism, where whoever controls executive branch operates without meaningful constraint. The stakes couldn't be higher for constitutional governance. Stay tuned.